Hello. In this unit, we will discuss coastal regulation in India. We will begin with discussing the significance and fragile nature of the coast that justifies the need for a coastal regulation. We will briefly see how the CRZ, that is, the Coastal Regulation Zone Notification, originated and evolved from 1991 to 2011. CRZ Notification 2011 is the current legal document that governs the development on the Indian coasts. We will discuss in detail the different provisions and stipulations of the CRZ notification. These provisions are to do with three key aspects. These are CRZ Classification and Regulations, institutional mechanism for CRZ regulation, and enforcement and implementation of CRZ notification. In the end, we will touch upon the concerns regarding the CRZ notification. Let us begin with understanding why do we need a coastal regulation law. Coasts are ecologically fragile areas. They are the interfaces where land meets the sea. They exhibit different ecosystems such as mangroves, sand dunes, coral reefs, salt marshes, estuaries, and lagoons. These ecosystems interact with each other and bring about changes in each other's temperature, salinity, and oxygen and nutrient content. These changes make the biodiversity of the coastal areas unique. Ecosystems such as mangroves provide protection against cyclones and storm surges. Besides being ecologically fragile, coasts are important because of various reasons. Their ecosystems such as mangroves and coral reefs are highly productive. They are linked with high fish production. They support livelihoods such as small-scale fisheries and salt making. Coast provides goods that are extremely productive such as fish, minerals, oil and salt. Ports, oil pipelines and industries that require large amount of water can be set up only on the coasts. Coasts are scenic places. Their beauty has turned them into premium areas for setting up recreational activities such as hotels and resorts. Demand of beach-facing houses is also on a rise. Since they are close to the sea, they make for ideal location for setting up trade centers. World's largest trade centers and cities are located on the coasts. Now let us look at the Indian coastline. India has a coastline that measures about 7,500 kilometers. On the east, it starts from the coast of West Bengal, passes Odisha and Andhra Pradesh, including now the newly formed state of Telangana, and ends at Tamil Nadu. The western side of the Indian coast begins with Gujarat and extends through Maharashtra, Goa, Karnataka and Kerala. While the eastern coastline is broad and flat, the western side is a narrow strip of rocky cliffs. Besides the coastal parts of the states, there are islands of Union territories of Andaman and Nicobar, Puducherry, Lakshadweep and Daman and Diu. These coastal areas are densely populated. As against the national population density of 324 people per square kilometer, the Indian coasts have an average population density of 500 people per square kilometer. Another peculiar feature of the Indian coastline is the conflict it witnesses between different interests. These are development, livelihoods, and conservation. Indian coasts support the survival of about 10 million fisher folk. They fish from the waters, dry the fish, mend their nets, park their boats, and even live in the adjoining land. They build their houses on the coast. As per the marine census data, there are more than 3,200 marine fishing villages in India. Another economic activity being carried out extensively on the Indian coast is salt making. Salt laborers lead a nomadic life. They spend 9 months in a year in makeshift houses on the coast. Estuaries, which is one of the significant ecosystems seen on the coast, support the livelihood of clam collectors. All these livelihoods put together make a significant number of people who are dependent on the coast for their survival. In the recent years, power plants and special economic zones are vying the same piece of land besides the usual demand for coastal land for setting up ports, oil pipelines, and tourist resorts. Apart from these uses, the Indian government has been notifying marine protected areas with the purpose of conservation of coastal biodiversity. So far, 5 marine national parks have been notified and another one has been proposed. All these uses are competing with each other for a share of the coastal land. The CRZ notification is meant to regulate the use of the coastal space among such competing industry, community, and public uses, while also maintaining the ecological viability of the coastal areas. Environment Protection Act 1986 is the umbrella legislation for the protection of environment in India. Its clause 325 gives powers to the MOEF, Ministry of Environment and Forest, to take measures necessary to protect and improve quality of the environment and to prevent and control environment pollution. The clause further states that the MOEF can restrict areas in which any industries, operations or processes cannot be carried out or can be carried out subject to certain safeguards. Using this clause, the MOEF introduced CRZ, that is Coastal Regulation Zone Notification, in the year 1991. It restricted certain activities in the coastal stretches of India, but several civil society organizations, fishermen groups, and committees appointed by the MOEF over the years raised concerns regarding the notification. We will look at these concerns in the later sections. Due to these concerns, the notification was replaced by a new notification in 2011, which currently regulates the development on the coast. We will refer to it as CRZ Notification 2011. We will now discuss the CRZ Notification 2011 and its clauses in detail. The CRZ Notification 2011 was issued with clear objectives. These are protection of livelihoods, conservation of coastal areas, and sustainable development of the coast. Before we look at the regulations and restrictions that the notification lays out, let us see how does the notification define the coastal regulation zone. For this, first we need to understand high tide line, that is HTL, and low tide line, LTL. High tide line is the line or land up to which the highest water line reaches during the springtime. Coastal Regulation Zone, as defined in the CRZ Notification 2011, is the coastal area up to 500 meter from the high tide line on the landward side of the sea and the area between the HTL and the LTL. CRZ has been defined for the water bodies such as bays, creeks, estuaries, rivers, and backwaters of the sea as well. It has been defined as the area up to 100 meter from the HTL along those water bodies that are influenced by the tidal action. Tidal influence is ascertained by noting the salinity of the water in these bodies. If the water has a salinity concentration of 5 parts per million in the driest period of the year, the water body is considered to be tidal influence. Let us now see the institutions created for CRZ regulation. CRZ notification suggests the constitution of institutions at 3 levels. At the national level, it suggests that a National Coastal Zone Management Authority, that is NCZMA, is to be constituted. At the state level, state coastal zone management authorities are to be constituted. And at the district level, all coastal districts are to have district level coastal committees, that is DLCCs. The notification does not prescribe anything on the composition of the coastal zone management authorities, but it mandates that DLCCs should have at least 3 representatives of traditional coastal communities. The role of National Coastal Zone Management Authority is to coordinate the work of the State Coastal Zone Management Authorities. The State Coastal Zone Management Authorities are to implement the CRZ notification in the state, and DLCCs are to assist the SCZMAs, that is the State Coastal Zone Management Authorities. Coastal Regulation Zone has been divided into 4 zones. These zones are based on the development level of a coastal stretch and its distance from the HTL. Let us look at these zones now. As you can see in the picture and as shared in the previous section, CRZ includes intertidal areas, that is areas that fall between the HTL and the LTL. area up to 500 meter from the STL of the sea, and area up to 100 meter from the STL along the tidal influence water bodies. Certain parts of the CRZ are ecologically sensitive. These include habitats of rare and endangered species such as horseshoe crabs, turtle nesting sites, ecosystems such as mangroves, sand dunes, and coral reefs. These ecologically sensitive areas and areas that are crucial for the health of the coast, along with the intertidal areas, form CRZ1. In the illustration, all the areas that are filled with red horizontal lines are CRZ1 areas. CRZ2 areas are those areas that are developed up to or close to the shoreline and fall within the limits of the concerned municipality. The illustration shows these areas as filled with green horizontal lines. Areas that are relatively undisturbed and not as developed as the CRZ2 areas have been classified as CRZ3 areas. Of these CRZ3 areas, the first 200 meters from the STL is classified as No Development Zone, that is NDZ. The areas within the 100 meter from the STL of the tidal influence water bodies are also included in the NDZ. The areas with yellow vertical lines in the illustration indicate the NDZ areas, and the areas with orange vertical lines form the non-NDZ part of the CRZ3. CRZ4 areas are water areas. It includes the water areas of the tidal influence water bodies and water areas up to 12 nautical miles from the LTL of the sea. 12 nautical miles is the distance up to which a country's territorial waters extend. Blue areas in the illustration are the CRZ4 areas. CRZ Notification 2011 puts a generic ban on carrying out of certain activities in the CRZ. But most of these prohibitions are accompanied with a set of exceptions. For example, setting up of new industries are not permitted in the CRZ, but there are exceptions such as ports, harbours and jetties. Similarly, land reclamation and bunding is not allowed except for construction of ports, harbours, control of erosion, etc. Discharge of untreated effluents, mining, groundwater drawal, and storage of oil and hazardous substances are other activities that are banned in the CRZ. You can see a complete list of prohibitions and exceptions in component 2, that is e-text of this module. CRZ notification also has certain regulations specific to each zone. Let us have a look at those now. In CRZ1 areas, new constructions, except for structures required for local needs, salt making, storage, desalination plants, construction of roads in intertidal areas which are not ecologically sensitive, are not permitted. In CRZ2 areas, buildings are permissible on the landward side of the existing road or building. This clause has been relaxed for slum redevelopment projects and reconstruction of dilapidated structures. However, reconstructions are permitted in this zone. In the NDZ, that is the no development zone, as the name suggests, no development or construction is permitted, except for constructions for certain activities relating to agriculture, horticulture, forestry, pastures, parks. Reconstructions and repairs of authorized structures are allowed, and also dwelling units of coastal communities are permitted in the zone between 100 to 200 meters from the STL. In the non-NDZ part of the CRZ3 areas, construction and repair of houses of local communities, tourism projects, public facilities for local inhabitants are permitted. In CRZ4 areas, activities related to traditional fishing are allowed. There are certain exceptions to these regulations as well. You can find those details in component 2, that is the e-text of this module. The notification gives special consideration to certain areas. Let us have a look at those now. In Greater Mumbai, roads have been allowed in CRZ1 areas. Rehabilitation of existing slums and reconstruction of dilapidated buildings has also been permitted. On islands in the backwaters of Kerala, 50 meters from the STL has been demarcated as CRZ area. All foreshore activities required for fishing are permitted in the notified fishing villages of Goa. It also allows for erecting seasonal temporary customary structures such as shacks, CRZ Notification 2011 has identified 12 sites that should be notified as critically vulnerable coastal areas, that is CVCAs. These areas are to be notified for the purpose of protecting the critical coastal environment and reducing the difficulties faced by local communities. Sundarbans, Gulf of Kutch, Gulf of Mannar, Bhitarkanika are a few examples. The notification further states that these areas will be identified, planned, notified and managed based on guidelines issued by the MOEF. Communities will be involved in the management of these areas, and the integrated management plans of these areas will be based on the conservation aspect and the needs of the local communities of the region. The notification also states that dwelling units of traditional local communities which are permissible but have not obtained formal approval under CRZ 1991 would be regularized under CRZ 2011. In its meeting in December 2011, the Karnataka State Coastal Zone Management Authority used this clause to regularize and allow reconstruction of a house for a traditional inhabitant in Udupi district. For all the projects seeking to be set up in the CRZ, CRZ Notification 2011 mandated a procedure. As per it, the SCZMAs, that is the State Coastal Zone Management Authorities, are to examine all proposals of projects to be set up in the CRZ. They, within 60 days, are to be forwarded from them to the different agencies. Projects listed in the Schedule A of the Environment Impact Assessment, that is EIA Notification 2006, are forwarded to the EAC, that is the Expert Appraisal Committee, and then to the MOEF. Projects listed in the Schedule B of the EIA notification are forwarded to the SEAC, that is the State Expert Appraisal Committee, and then to the State Environment Impact Assessment Authority, that is SEA. Construction projects to be set up in the CRZ2 zone with an area of less than 20,000 square meters are to be forwarded to the SEAC and then to SEA. And the construction projects to be set up in CRZ2 which are of an area of more than 20,000 square meters are to be forwarded to the state planning authorities. All other projects listed in the CRZ notification are forwarded to the MOEF. CRZ notification also stipulated that the proponent, while applying for environment clearance under the CRZ, should submit the application with certain documents such as Environment Impact Assessment Report, Disaster and Risk Management Report, and CRZ map. CRZ notification further stipulated that all coastal states will formulate Coastal Zone Management Plans, that is CZMP. CZMP is a document that has all the CRZ zones demarcated in it. SCZMAs, that is the State Coastal Zone Management Authorities, use it to arrive at decisions on project clearance, identification of violations, and regulation of development activities in the CRZ. Currently, SCZMAs are using the CZMP prepared under CRZ Notification 1991. Although the new notification that came in 2011 asked all the states to prepare new CZMPs by January 2013, the states are still preparing it. MOEF has already extended the deadline for CZMP preparation twice, and a third extension is expected. Now that we have looked at the key provisions of the CRZ Notification 2011, we can summarize the functions of various institutions with respect to the key aspects of the CRZ notification in the form of a table. For CZMP preparation, SCZMAs are to coordinate the activity, NCZMA to monitor the progress of the activity, and MOEF is to approve the CZMP. SCZMAs recommend the revisions to the existing CZMP. For example, moving an area from one zone to another or moving certain areas to and from the CRZ, and NCZMA decides on those. SCZMAs examine project proposals and recommend them to the concerned state government or the MOEF. Violations are to be identified, verified and corrected by the SCZMAs, and NCZMA reviews the progress. Conservation related activities such as identification and preparation of management plans for ESAs and CVCAs are carried out by the SCZMAs, and these plans are to be approved by the NCZMA. DSCCs have been assigned the task of assisting the SCZMAs in the implementation of the notification. Besides these activities, MOEF keeps issuing directions and guidelines for the SCZMAs regarding their key functions. As mentioned earlier, certain concerns regarding the CRZ notification 1991 were raised by different groups. Let us look at those now. CRZ notification 1991 was a uniform notification for a coastline of 7,500 km, spanning over 9 states and 4 union territories. It did not take into account the diversity of land use, dependent livelihoods, and population densities across the coastline. The demarcation process for tidal lines, HTL and LTL, was confusing. Local departments such as Panchayat found CRZ maps difficult to use. There was a lack of comprehensive coastal planning and no directions were provided for preparation of CZMPs for the CRZ. Certain terms such as foreshore and waterfront activities, traditional rights and customary uses, reconstruction, repairs, buildings, activities, temporary structures / sheds used in the notification were not defined. Lack of consideration of the concerns of coastal communities was another concern. The CRZ notification 1991 was amended 25 times in the 2 decades of its existence. These piecemeal amendments made it fragmented and nearly impossible to implement. While some of these concerns were addressed in the new notification in 2011, certain issues still demand attention. The CRZ notification 2011 mandates that project authorities submit half-yearly compliance reports with respect to the terms and conditions based on which the environment clearance has been granted to the project, to the concerned state or union territory CZMA. However, the notification does not have any mechanism for conducting surprise visits and inspections for post-clearance monitoring. The issue in general has been given not enough attention. The notification does not provide any procedure or timelines for identification of violations. It does not suggest what action should be taken against the violations once they are established. The National Green Tribunal, while hearing application number 49 of 2012, observed the same. In its judgment on 11th April 2013, it outlined a procedure for the same for Goa SCZMA to follow in all its cases. Certain terms mentioned in the notification still require clear meanings and definitions. For example, substantially built up urban areas for demarcating CRZ2 zones was not defined in CRZ 2011. Dwelling units of traditional communities which are permitted in CRZ has not been defined in the notification. SCZMAs have started coming up with their own definitions for their use. Let us see an interesting case where the CRZ notification came into play in the power tussle between the MOEF and the SCZMA. The Setu Samudram Shipping Canal project to link Park Bay and the Gulf of Mannar between Tamil Nadu, India and Sri Lanka was inaugurated by the central government in 2005. This was done despite the accusations from the state government that the project has subverted environment clearance and has overlooked the concerns of fishermen. Since part of the project was falling within 12 nautical miles of water area from the LTL, it required to be examined by the Tamil Nadu State Coastal Zone Management Authority. Using this ground, the government of Tamil Nadu objected to the project on the ground that it had not obtained the mandatory CRZ clearance. Hence, in April 2013, the state government sought a direction from the Supreme Court to the centre not to carry out any further work on the project. With this, we have completed the module on CRZ regulation.